Thank you, and thank you for your patience. We have reached a decision in the matter of the Licensing Act 2003 notification of temporary event for pier decking at Gaiety Bar, South Parade Pier, the objection notice. All parties shall receive written confirmation of the decision and the reasons. The decision. The subcommittee has considered very carefully the temporary event notice and the objection notice submitted by Environmental Health. It gave due regard to the Licensing Act 2003, the licensing objectives, statutory guidance and the adopted statement of licensing policy. The subcommittee considered the representations both written and given at the hearing by both parties, including the additional papers submitted in advance by both parties. Example would be the noise management policy, support letters, noise abatement notices and email correspondence between the parties. Human rights legislation and public sector equality duty had been borne in mind while making the decision. The 10 outline has a proposed event at South Parade Pier on the 31st of July 2022 and indicates that sale by retail of alcohol and regulated entertainment shall take place between 12 midday and to 8 o'clock in the evening. The subcommittee noted that environmental health objection was based on concern regarding amplified music on the basis that a previous event at the same location had caused a statutory noise nuisance leading to the service of noise abatement notices under the Environmental Protection Act 1990. As a result, a consideration of the matter before the subcommittee was limited to whether regulated entertainment of the premises for the proposed event would undermine the prevention of public nuisance licensing objective and whether in the circumstances it would be appropriate for the promotion of that licensing objective to issue a counter notice in accordance with section 105 2b of the Act. The subcommittee accepted legal advice that as the proposed premises did not have the benefit of a premises licence, conditions could not have been imposed. Accordingly, the decision was in effect whether the event could be allowed to proceed. After having heard all the above evidence, the subcommittee determined not to issue a counter notice. The subcommittee acknowledges that a previous event on the 2nd of July this year caused a statutory noise nuisance leading to the service of abatement notices. This failure was identified as a lack of control and management of the event. Despite issues being brought to the attention of the premises user and action being taken, officers went on to witness a nuisance within residential premises. Environmental health officers remain concerned that training and suitable measures have not been implemented to satisfy them that the risk of public nuisance has not been addressed. The qualifications of the person with overall control of the proposed event have not been detailed. However, the subcommittee heard evidence from the premises user that significant changes have now been implemented with a noise management plan in place following the instruction of a noise consultant. Any confusion as to responsibility and control of the sound systems has been addressed, and the nominated individual was well experienced and, in the opinion of the noise consultant, a very competent person to be in such a position of control. In this respect, the subcommittee was satisfied on the balance of probabilities that the position is materially different to the previous event. The fact an abatement notice is in place does mean that there will be serious consequences in the event that a further statutory noise nuisance is allowed to result from the regulated entertainment. A reactionary system to control is now proposed with regular monitoring and logging. This has been a very difficult decision, and it is fair to say that we believe a robust management plan is in place and steps taken to ensure that different equipment will be provided with different management. The premises user has made it perfectly clear that they understand the states could not be higher at this juncture. If assurances made to the subcommittee are not satisfactorily implemented, there will be serious repercussions, both in relation to the potential prosecution and the impact that this will result for the viability of future planned events. It was common ground that environmental conditions, predominantly the weather and the sea state, can immediately affect the impact of amplified sound in this location. With regular monitoring, there will now be an effective control to changes in conditions should they occur. Despite the very serious breaches allowed to continue on the 2nd of July and to a lesser extent on the 3rd of July, the subcommittee is satisfied on the balance of probabilities that the premises user has now implemented sufficient changes to temper the potential risk. There is a right of appeal to the Magistrates' Court, and formal notification of the decision will set that right out in full. Thank you. Thank you.